What is the definition for a non-resident Indian, and what are the criteria to be categorized as an NRI? Non-resident Indian, or NRI, is a very broad term used to define those Indian citizens who are residing overseas, or overseas citizens who have an Indian origin and are not residing in India. Essentially, the categorization of an individual as an NRI is determined based on the residency status. There are two regulations or laws that define the status of who is a resident in India, and those who do not meet these criteria are determined to be non-residents of India. The two laws that define the criteria of residency in India are the Foreign Exchange Management Act, FEMA, 1999, and the Income Tax Act, 1961.
Let's now understand the definition under FEMA and who can be determined as a non-resident of India as per FEMA. As per Section 2(v)(i) of FEMA, an individual is considered a resident of India if he has been in India in the preceding financial year for more than 182 days. In India, the financial year is from April 1st of a year to March 31st of the subsequent year. Residency is the primary basis for the determination of whether a person is a resident of India. Other parameters, such as citizenship of the individual, purpose of travel overseas, etc., do not determine residency. So, if the person has resided in India for more than 182 days in the previous financial year, then the person is deemed to be a resident of India. Hence, at a very broad level, as per FEMA, a non-resident individual means a person who's been resident outside of India for more than 182 days in the previous financial year. FEMA also considers intention to stay for an indefinite period overseas, such as for employment, studies, business, etc. So, a person who is going overseas to take up employment or a student who is going overseas for higher studies can be considered an NRI once they have gone overseas. There is another category of people who are defined as Overseas Citizens of India, OCI, and OCIs are also treated on par with NRIs for the purpose of financial transactions, such as banking. Let's now understand the definition of an OCI. The Constitution of India does not allow holding dual citizenship, and so an Indian citizen cannot hold citizenship of another country simultaneously. Based on the recommendations of a high-level committee, the Government of India decided to grant Overseas Citizenship of India, OCI. This is a category of immigration status that was introduced by the Indian government in 2006 to facilitate easier travel and residency rights for foreign citizens of Indian origin. The definition of who is a person of Indian origin is specified as a foreign national who was eligible to become a citizen of India on January 26, 1950, or was a citizen of India on or at any time after January 26, 1950, or belonged to a territory that became a part of India after August 15, 1947, and his or her children and grandchildren, is eligible for registration as an Overseas Citizen of India, OCI. Minor children of such a person are also eligible for OCI. Any person who or whose parents or grandparents were born in India as defined in the Government of India Act 1935 as originally enacted, and who was ordinarily residing in any country outside India was eligible to become a citizen of India on January 26, 1950. A spouse of an Indian citizen or an OCI is also eligible to apply for an OCI status. However, if the applicant had ever been a citizen of Pakistan or Bangladesh, he or she will not be eligible for OCI. While the OCI status was launched in 2006, prior to this, until the year 2015, there was also a category called Person of Indian Origin, or PIO. Foreign Exchange Management Act 2000 defines a person of Indian origin, PIO, as a person being a citizen of any country who at any time held an Indian passport, or a person who himself or either of his parents or any of his grandparents were citizens of India by virtue of the Constitution of India or the Citizenship Act, 1955, or spouse of an Indian citizen, or spouse of a person of Indian origin, PIO. It is important to note that the citizens of Bangladesh, Pakistan, Sri Lanka, Afghanistan, China, Iran, Nepal, and Bhutan are not considered as PIO even if they satisfy the conditions under FEMA for different purposes under different regulations. The Government of India, as per the announcement in January 15, has subsumed the PIO status under the OCI status, and hence the PIO status has been merged under the OCI status. The PIO status holders are deemed to be OCIs, and holders of PIO cards were given the option to apply for the OCI card free of cost till 2021. So, in summary, citizens of India who are not resident in India or overseas citizens of India who are also not residing in India for over 182 days in the previous financial year can be determined to be non-residents of India or NRIs. Having learnt about the definition of NRIs and OCI as per FEMA, let's now understand the definition of resident of India under the Income Tax Act, 1961. As per Section 6 of the Income Tax Act, an individual is deemed to be resident in India in any previous year if the person is in India for a period of 182 days or more during the previous year, or if the person is in India for a period of 60 days or more during the previous year, and 365 days or more during 4 years immediately preceding the previous year. However, if an Indian citizen who is already overseas or an OCI visits India during the year, the period of 60 days shall be substituted with 182 days. The similar concession is provided to an Indian citizen who leaves India in any previous year as a crew member of a ship or for the purpose of employment outside India. As per the Indian Budget 2020, referred to as the Finance Act 2020, an amendment has been introduced that the period of 60 days shall be substituted with 120 days if an Indian citizen whose total income in India, other than income from foreign sources, exceeds 15 lakh rupees during the previous year. Income from foreign sources means income which accrues or arises outside India, except income derived from a business controlled in or a profession set up in India. Also, in the Finance Act 2020, Section 6, 1A of IT Act 1961, the deemed residence criteria based on income has been introduced as per which an individual, being a citizen of India, having a total income other than the income from foreign sources, exceeding 15 lakh rupees during the previous year, shall be deemed to be resident in India in that previous year, if he is not liable to tax in any other country or territory by reason of his domicile or residence or any other criteria of similar nature.
We have studied the definitions of who a resident of India is, and therefore who becomes a non-resident of India under both the FEMA and Income Tax Act. It is pertinent for NRIs to understand that FEMA and IT Act have different applications for different purposes, and they could be NRI under one act and not in the other act. So it is advisable to check with your bank, chartered accountant, or your financial consultant on a specific basis before you proceed with a transaction. We hope you've benefited from watching this video. Please do subscribe to our channel for more such informative videos. Thank you.